Rest of your weekend.
Next, Newsmakers with Sheila Bair, Chairman of the Federal Deposit Insurance Corporation. Then remarks by Fed Chairman Ben Bernanke. After that, former Secretary of State Condoleezza Rice.
This week on C-SPAN's Newsmakers, Sheila Bair, who is Chairman of the Federal Deposit Insurance Corporation. She's one of the government officials who will be primarily responsible for implementing the new Dodd-Frank financial regulation laws recently signed by the President, and to address the mortgage crisis currently facing our country. Here to question her, Deborah Solomon of the Wall Street Journal and Tom Braithwaite of the Financial Times newspaper. Mr. Braithwaite, first question.
Chairman Bair, we're in the middle of a foreclosure crisis. Some of the biggest banks in the country have suspended foreclosures. To what extent is this a failure of regulation?
Well, I think that's a very good question. It turns out that it looks like this was industry-wide practice, at least with large servicers. The banks where we are the primary supervisor, we've been collecting information. We're fairly confident they have not been implicated in this, but that's because they have small servicing portfolios. They do it in-house, and so I think this is really a symptom of size, and it's very unfortunate. And so in our backup supervisor capacity, we are working with our regulatory colleagues. I think it's necessary for the regulators to go in and verify. We've been told that these files, this is a process issue, and that all the information's in the file. The problem is that the person who needed to sign the affidavit had not been looking at the file before they'd done so. So we need to independently verify that. I think we also need to make sure that good title is in these files, and that going forward, this is obviously fully remediated, and that the adequate staffing is provided so that there's full compliance with the individual state laws. Foreclosure is a very serious thing, and it should only be undertaken after loan modification efforts are not feasible, and that the files are fully documented, and there's a good case to move forward. So I think we need to independently verify that all of that has occurred, but we really don't know yet whether this is a process issue or there's more underlying substantive issues. So I don't think anybody should jump to conclusions until we've completed our review process.
And we should explain you're the primary regulator for thousands of smaller and medium-sized banks up and down the country.
Right.
But this affects primarily the largest banks. I mean, you do, though, insure these banks' deposits.
Yes, we do. Yes,
and
we
so
do.
You're obviously concerned. Are you concerned of knock-on effects there for the banks themselves?
I think that we are, again, as backup supervisor, we are working with our colleagues at the OCC and the Fed. My personal view is that the banks should be doing rigorous internal analysis of what the range of risk exposures might be. Clearly litigation risk and regulatory risk, and state AGs obviously have initiated their own investigative process. So we need to get a full handle on all of these issues. Again, if it turns out that this just was a process issue, then I don't anticipate the exposures to be significant. If it turns out to be something more fundamental, then we'll have to deal with that. But I think we need to get all the information before we jump to any conclusions. And I certainly don't think people should be viewing this as a broader problem than it is until we have the facts.
And just finally, if I may, on foreclosures, you're not someone who wants a nationwide moratorium.
You know, I think certainly foreclosure should, if there's any question about whether the documents are there and it's appropriate to move forward with foreclosure, those should be halted until the case files are reviewed for all pertinent information, that that a new affidavit is executed where the original one was not sufficient. So clearly all of those processes need to be in place, but once that has occurred, then no. I think a lot of this, the sad fact is a lot of this is vacant property, some of it's investor owned. Even for the owner-occupied, and we think our prioritization for the regulators should be in making sure those owner-occupied homes, all the processes have been followed. But even there, you know, it may well be the case that it have been 12 to 18 months since a payment has been made. And at that point, it's just necessary to move on with that. And it's tragic. I don't like it. But the market has to clear. And if the family just can't simply afford making even a modified payment, then something else has to happen, and I regret it, but that's just the way the system has to work.
This week, your agency took the first step towards ending too big to fail. It was a first step in terms of writing the rules about how creditors, people who lend money to financial institutions, will be treated in the event of a failure.
Right.
But I'm wondering if you could tell us more broadly, how does the FDIC envision the government being able to take over a large Lehman-like firm? Will you swoop in on a Friday, close it, and open it on a Monday the way you do now with some of the smaller banks?
Right.
And if not, how do you prevent making the situation worse by sort of showing your hand that the government's going in and triggering a run on a Merrill or a Lehman or a Bear Stearns?
Right. Well, those are very good questions, and I think part and parcel of the liquidation authority is the ability to require advanced resolution planning by all large institutions. Any bank holding company with assets more than $50 billion has to develop a resolution plan that's acceptable to us and the Fed. And then any other non-bank entity that is designated as systemic also has to file a resolution plan. So we should have plans in advance on the shelf, and those will be continually updated and monitored. We are setting up a new complex financial institutions office that will be staffed with experts in larger institutions, people who understand their international operations, their derivatives operations, who will be working on an ongoing basis with these institutions. I anticipate the resolution planning will be a continual iterative process. So we will have a plan on the shelf if something happens. I think with the Lehman situation, actually Lehman is of a size. Actually with Lehman, there was at least one ready buyer for the bulk of Lehman, and that sale did not go through. I was told through Rank Paulson I wasn't involved in this because of regulatory concerns about the credit quality and the need for speed in terms of making a decision and what kind of credit risk would the acquirer have taken on, and I think FSA had been concerned about that, and so the sale didn't go through and a bankruptcy ensued. But with our process, we could have worked with the UK regulatory authorities to address their concerns. We can hold back the unsecured debt and the equity and the receivership for loss absorption. We can hold back some of the bad assets too for those stakeholders to take the losses and move the better part of the institution and market it and sell it very quickly if you do have ready buyers. We also, I think we have the ability and would, on an overnight basis, move the institution into a bridge institution. And we have the ability to continue to fund operations as it's wound down if you couldn't arrange an immediate sale. So those tools are all in place. So they've been used for a long time with banks. And I think I don't want to underestimate the difficulty of this. It's never going to be, whether it's bankruptcy or a resolution process, it's going to be a difficult, challenging process, but these tools that we have now are so far superior to what we had going into this crisis. And again, the ability to advance plan, to work with international regulators, those are some things that the FDIC can do that a bankruptcy court just can't do. So the advanced planning process and the ability to see the red flags and go in there early is very important, and that's what we do with banks as well. So it's a much superior process than what we had before, but one appropriately that imposes the losses on shareholders and unsecured creditors, as is the case with the bankruptcy process.
And just to follow up, what you did on Tuesday was you sort of set out how creditors would be paid.
Right.
Obviously, there was a huge uproar when AIG was taken over by the government, and the government made the counterparties, some of their lenders, whole.
Right.
I'm wondering, do you envision ever a situation where you would pay off, people at par?
No, no, we don't. I mean, the two limited places are where it's necessary to continue essential operations, where it maximizes recoveries. So I suppose you could have a situation, for instance, if the institution had a big derivatives dealer that someone wanted to acquire, and the derivatives are generally collateralized. There's a question if their collateral is insufficient. That's something we also address with this rulemaking. So if you have your collateral is going to be marked at fair value, and so if you're unsecured, that will be available for loss absorption too. But it may be an acquirer of a derivatives dealer would want to maintain those customer relationships, so they would pay us enough of a premium to cover what we would have saved by imposing loss on the unsecured portion. So that, I think we talked about that a few days ago, it would be a mathematical determination. But if not, all the unsecured portions of those derivative counterparty positions would be subject for loss absorption. And derivatives counterparties need to understand that and make sure that they have adequate collateral if they want to be fully protected in a receivership type of situation.
Chairman Bair, are you satisfied with how Dodd-Frank addressed derivatives?
Well, I think it's a huge improvement. I do. There's a lot of implementation work, with margining and capital requirements, and trying to move a lot of this that's now off exchange onto regulated exchanges and central clearing. So there's a lot to deal with implementation. We do not have the lead on this. This is appropriately the CFTC and the SEC, but they're very good at consulting. Gary Gensler, I think, I have a lot of confidence in him. He's been very good at reaching out to us, and they have the lead on most of the derivatives pieces of this. You know, I have a lot of confidence in the regulatory process, but on that in particular, as with the case of the Volcker Rule, a lot of it's going to depend on regulatory implementation and the vigor with which we proceed.
This is C-SPAN's Newsmakers program. Our guest is Sheila Bair, Chairman of the FDIC. Deborah Solomon of the Wall Street Journal, Tom Braithwaite of the Financial Times are here as our reporters. Next question.
I'd just like to ask, under Dodd-Frank, the Financial Stability Oversight Council was created, and this has you sitting alongside Timothy Geithner, the Treasury Secretary, alongside the Chairman of the Federal Reserve. And we saw this up and running for the first time a couple of weeks back. It surprised me how many people, and I should have known this, were around the table. And I just wonder, this includes the credit union representatives, the insurance representatives, I just wonder at times of crisis how effective this sort of war council will be with all these people around the table.
Right. Well, not all of them are voting members, but even if they were, I think, you know, if there was one lesson I learned during the crisis, that people with very diverse viewpoints can come together and make a decision, and make a decision quickly. We did it over and over again with our own process for systemic risk determinations. That is a fairly elaborate process requiring a supermajority of my board and the Federal Reserve Board and the Secretary of the Treasury, and with the concurrence of the President. And those decisions got turned around very quickly. So I think when the situation dictates, the decision-making can occur. On the other hand, if the situation is not so clear that action is needed or what kind of action is needed, sometimes a more deliberative process can help. I think, you know, it's like anything, you need a balance. But I'm really not worried about. I think in a crisis situation, I think we can come together. If I have a concern, it's more about the rulemaking process, and there's a lot of elaborate consultation processes, which is good. You know, I always want input from other regulators, but at what point does that facilitate reform or potentially impede reform if there are just so many sign-offs and so many people you have to talk to? So I think that's really where we're going to have to work to make sure FSOC performs the way it should.
You delayed the resolution rule that Deborah mentioned because I think the Treasury wanted more time, or other members wanted more time for consultation. So that's the sort of thing you're talking about. Yeah. It's not as efficient as it could be.
Well, and we were happy to delay it, and we did, and we proceeded. And I think everyone may not agree or not with the rule, but they were comfortable that they had enough time to read it and give us their input. So I think that worked not perfectly, but we're learning, and we were the first one out with something that required consultation, and there had been several weeks worth of staff discussions, and I had provided about 10 days of consultation at the principal level, and we added another week or so to that, and that was I was happy to do it. So I think we would like to develop some standardized procedures for consultation so everyone knows. And I think also, I hope we will all kind of get our hands up. You know, if someone has an interest in our resolution rules, or we have an interest in the CFTC's derivative rules or whatever, I think it's incumbent on us to get our hands up early, and we have a view on this. We'd really like to be kept in the loop. You know, not in this last minute kind of thing. I think we all need to make sure that doesn't happen.
Chairman Ben Bernanke said recently that people would be amazed at the gaps in regulatory oversight. And one of the things that the Fed is going to have to do, but this council you're a part of is going to have to do also, is to figure out which companies should be determined systemic. In other words, you know, which companies could cause a broader financial collapse if they were to go down beyond just a set of companies that are already designated as such. And I'm curious, as somebody who was early to, you know, seeing problems developing in the mortgage market, do you see a need to regulate, to deem like hedge funds and private equity funds as systemic, or do you have in your mind what criteria should be used to determine those firms?
Well, I don't want to be too definitive in responding to that because we're out for comment on that right now, and I don't want to lead comments, and we want to look at the comments before we make some decisions there. But I think, generally speaking, with me, it's more about interconnectedness than it is about sheer size. And you're right, the criteria should be what will be the broader ramifications if this institution gets into trouble. But that said, I think those ramifications should be focused on the public interest. For instance, credit support, where there be a major disruption of credit availability if an institution were to get into trouble. I think just the fact that, you know, 5 other financial institutions or their counterparties or hold their debt and will take losses as they go down, that should not be the criteria. And I think to the extent there's too much internalization of risk within the financial sector, that's something we need to deal with now on a supervisory